Julie, Ellyn?
Well, I mean, I think that it gets back to that reasonableness, a subjective term that I think when you are dealing with such a short amount of time, and ideally there are going to be a lot of people out there probably interested in having parades. I think it depends. It's kind of balancing, accommodating all of those who do want to have the parades with the amount of space available. And I think that second part, the amount of space available, making sure that there are ample opportunities both within the clean zone and outside the clean zone where people can assemble and have parade routes. But I think that 60 minutes is the reasonableness, as we were talking about earlier, it can really mean a lot of different things. The city might think it's reasonable, but do the groups, outside groups, think it's reasonable? And what is, if no matter how much time, who would be happy with this set amount of time for a parade?
Well, yeah, and some people might come with a group of 100, and you might be able to march 100 through your parade route within an hour. But another group called me today, and I said, how many are you thinking about bringing? And they said, easily 1,000. So to get 1,000 people organized and that type of thing, and then marching, and going where they need to go, et cetera, and have all that done in 60 minutes could be a real challenge. Even if they're peaceful, then all of a sudden TPD is going to say time's up, and what if they're only halfway done with the route? And these are some really practical issues that I hope City Council and the city continues to address. Let's move on. There's another provision in the ordinance having to do with the prohibition of masks. And it's kind of interesting because as we all know, the use of masks, I think, came into vogue in the 60s and 70s. You always saw the Richard Nixon mask. I think in Tampa we'll be seeing the Romney or the Santorum, or maybe even the Bob Buckhorn mask might reappear. But anyway, the ordinance prohibits masks throughout the clean zone, and the clean zone has been defined not only as, I expected the clean zone to be, downtown Tampa, but the clean zone as it's defined in this particular draft not only includes downtown Tampa, but includes Ybor City and Channelside, which are sort of an extension of downtown. But then it jumps into some severely residential, purely residential areas, including Davis Island, Hyde Park, I think it's got you, Rob, Davis Island, Hyde Park, Tampa Heights, and up the river in the Riverside area. Purely residential areas that just happen to be butted up against downtown. So the scenario that I thought about, trying to be, since we're in a law school professor, I've tried to come up with this law school exam type thing. So what I was thinking about was, okay, you got a group of 4 protesters and they're totally worn out and they decide to take a lunch break. So they go up the river to Rick's on the River. Everybody know Rick's on the River? It's about a mile north of here, right up the river, and it is in the clean zone because it's just south of Columbus Boulevard. They bring their Bob Buckhorn masks and they put them on at lunch while they're discussing, their next, their next activity at the convention. Under Section 8 of the current draft ordinance, they are clearly in violation of that provision by wearing the masks in the clean zone, anywhere in the clean zone, even if it's a mile up the river. They could get arrested for violating that city code, potentially convicted of a second-degree misdemeanor, and serve in jail for 60 days. Professor Virelli, as a common law professor, how does that regulation sit with you? Is it reasonable, time, place, and manner restriction? And you are sitting next to the city attorney. No.
And a student who now know what she feels like when she's in my class. Thank you very much for the hype out. I think the concerns are the same that they always are. There is First Amendment precedent that says anonymity is a protected right, and anonymous speech is a protected right, the wearing of masks is a protected right. That doesn't change the existence of the time, place, and manner requirement. I think questions of reasonableness, the context, the facts are going to make all of the difference there. Is there an alternative avenue for that speech? Is there a significant government interest at play in prohibiting masks in that way, in that time? I think you're going to see conversations about that. And as I said, let me remind you, con law is generally not about answers all the time. Mickey is absolutely right, and I'm not surprised that I'll probably say that lots of times today, that it is very much contextual and is very much a matter of the audience and the environment in which you are expressing your views. I will say, I am causing trouble because I think that's my license as an academic, but what I thought of when I read this was a burqa.
Was it what?
A burqa. Now I've really caused trouble, and I apologize to the city council people in the room, but I think those are the sorts of First Amendment issues that are invited by all of these questions, and time, place, and manner is primarily a speech issue, not a free exercise issue, and so I think there are things at play here that and I will say, it is impossible, in my view, for any legislature to anticipate in its entirety, and certainly for a drafter to anticipate. So I am not intending to besmirch, I promise, sir, the efforts made. But I think these issues are inevitable. They always crop up at this point, and I have the unique position of being able to identify them and not have to solve them. So I will stop.
And just in case y'all want to know why I'm staying so quietly here, is because you have to be arrested first for my office to become involved, and it's at that point that we would then address the constitutionality of the underlying ordinance that exists. And so that's why I said 7 to 10 days. I anticipate my job will not stop, and as a matter of fact, I have a colleague here from Bartow, the 10th Circuit, who does our appellate work, and that goes to show you when we talk about partnerships, we are anticipating that perhaps the constitutionality of the ordinance may come into play very quickly as soon as the very first arrest is made. We have to have some emergency procedures in place. That's what partnering is about. I think the city understands what my role is. I know the community understands it, and I assure you that we are anticipating quick work probably on day one. And we stand ready to do so. And now I know all my friends that I can call to assist in this. So they will have to give very specific answers on the first day. But thank you.
Thank you. Professor, you mentioned the word context also. And one of the things I think I was stressing was the context of where these folks are having their lunch. They're having it out in a residential area at a restaurant that, frankly, any one of us who knows the geography would know that it really has nothing to do with that downtown area. Julie? Well,
and as you know, John, there are a lot of laws that are on the books that say you cannot wear a mask during the commission of a particular offense. What we're looking for, is this ordinance too broad? Is it touching way too many areas outside of where the immediate convention is occurring, where the immediate protesting is anticipated? Are we going too far out where it will impact those of us that live in these areas and have no intention of participating perhaps in the convention? So we're looking at the constitutional attack on, is it too broad? We understand what we're trying to avoid, but once you get outside of this immediate area, do you really need to get into those communities that are contiguous to the downtown area?
Yes. Thank you, Julie. We're not going to accommodate that right this second. But Professor, you and then Mickey, I see you got your mic at the ready.
Thank you. I'll just say two quick things. I think with the hypo you identified is a reasonableness question primarily. I think as the reasonableness of the restriction wanes, the government interest rate wanes with it. And the opportunity for alternative communication sort of follows suit. So I think that is a much better example of a potentially unconstitutional application of the mask provision, I think, for sure, the hypo you gave. I also I caused trouble with the hypo before, and let me just say this. I tell my students all the time, and it's true, all branches of government are constitutional actors and constitutional interpreters. And from my point of view, I gave an example of a burqa. I think that's an example of a potential constitutional issue that is resolved in the enforcement process as much as it's involved in the legislation process. And I don't envision a significant amount of law enforcement focusing on people wearing religious symbols as masks under this provision. And that is part of their both constitutional duty, responsibility, prerogative, and the way that I think law enforcement generally operates. So I think it's not a lack of faith on my part that I cite that. It's an example that everybody is in this together on some level when it comes to the constitutional interplay with these issues.
Mickey?
Another way of looking at the reasonable time, place, and manner restrictions is that whatever the statute is, it doesn't restrict any more speech than is necessary to achieve that governmental interest. So I think in this case, given where they're located, what governmental interest is being served by possibly arresting 4 people having lunch together wearing masks. And again, it's very fact-specific, so it's just people out there are going to have to exercise common sense on both sides of the issue. And if people do that, the likelihood of unnecessary litigation and lawsuits is decreased. The problem is, without preparation, without discussion, without training, in the heat of the moment, things happen. And that's where the problem lies.
Thank you. Ellyn, the media reported this week the interesting twist about the types of things you can bring into the clean zone and into the public viewing area. Specifically, you can't bring chains. You can't bring chains in, knives, pointed 2x4s. You can't bring toy guns or water pistols and that sort of thing. But then, as the reporters indicated, and I'm sort of embarrassed because I didn't even catch it, but that you can't bring all these things because they might be used as weapons, but you can bring licensed firearms. So okay, there you go, law student. Explain that one.
I told Professor Virelli that I would defer to him on these issues. I mean, we were joking about it, but you can't bring a super soaker, but then how are you going to defend the handgun bullets that are coming at you?
Right.
The tripods aren't there, but so I mean, I understand the. I guess I was a little too close there. I think that. It's a state statute, and how that really matches up with this ordinance will be interesting, because the government interest here really is public safety. And when you do have a lot of people assembled where there's a lot of passion and emotions are high, I think the challenge is going to be in the enforcement. And yeah, I think that being able to have a concealed weapon is one thing, but preventing people from using it is going to be the utmost responsibility of the law enforcement.
Thank you, Ellyn. Jim, give us a little rendition on how, because originally I think I read in the paper that originally it prohibited handguns or that sort of thing, but then you all realized the state statute was there.
The state statute is there, and it's very clear what it says, and so whether that was in our early draft or not.
Tell what it says.
Excuse me?
What does it say?
I mean, it basically preempts local governments from regulating firearms and other things, and it has very severe penalties for violating that. And so, we can look into some alternatives, but we may want to call Governor Scott on that, or the legislature.